Thank you, sir. Salzmore, I just want to round off now on the topic of the potential need for more change in policy and practice. And you've got a helpful reflection section of your statement. Could we look at one part of that? It's page 51, at paragraphs 173 to 174. You candidly say there that there is also clear inconsistency around the application of prevent thresholds, where referrals in cases do not have a clear ideology. Ideology is only one of multiple considerations when assessing an individual's susceptibility to radicalization. Terrorists can hold a range of personal grievances and adopt ideas from different ideologies or subcultures. For some individuals, fascination with extreme violence could be an early indicator that an individual is on a pathway to terrorism. And then at 174, you say the thresholds review, and that's the document that we've been looking at a little bit and I'm going to come back to, but the thresholds review found that the lack of a clear ideology was a significant factor in decision-making at each threshold. This often led to referrals not being made or not progressing through the prevent system, with an overemphasis on ideology, meaning that other markers for susceptibility to radicalization could be missed. In my view, we must do more to clarify that a clear, identifiable ideology is not mandatory to make or progress a prevent referral. Now, those words, if I may say so, are admirably clear, but it does mean that even looking at this report from the last month, there is still a problem here in the fact that a clear ideology is not required for prevent, still not being fully understood and recognized. Would you agree?
Yes.
And so now, more than 6 years on from that joint letter, still not enough has been done to deal with this important area.
I think that what we have now is an inconsistency. So in some areas, I think this is being adopted and an effective approach. I think in some other areas, we've got inconsistency in decision-making as those referrals come through into the system. We must do more to drive out that inconsistency, and we must do more in guidance, training, and keeping on building awareness.
If we look at paragraph 107 on page 34, you say in relation to AR that you have considered whether the Home Office would have expected AR to be referred to Channel had he been viewing similar material that was consistent with a single ideology. While professional judgment may vary and there's a risk of oversimplifying when applying counterfactuals, I consider it more likely that AR would have been referred to Channel in 2019 if the material he'd been reviewing and comments he had been making had aligned with a single ideology. He would also have been more likely to have been adopted in as a Channel case. So what you were telling us was that the lack of a single clear ideology appears to have made a difference in AR's case back at the time, yes?
Yes.
And in the two paragraphs that I've taken you to at 173, 174, although you say that improvements have been made, and in some cases the understanding is now good, as the director of Prevent in the Home Office, you still don't have confidence that enough has been done to ensure that the system is as rigorous and as clearly understood as it needs to be.
Yeah, I think there's a lot more to do.
Thank you. And if it were to be suggested that given the 6 years since the joint letter and other steps had first started to deal with it, if it were to be suggested that the Home Office has failed to act with sufficient rigour and urgency in this area, what would you say?
I think that at the time of AR's referrals, it was in policy and processes at the time and training that these sorts of cases could have made their way through to Channel. I think that the position now is even more clear than it was then, but there is always more work for us to do. The different types of risk indicators that we see change over time, and we have to keep adapting with that.
Within the thresholds review, if we look at HOM 4090, and if we go to page 7, please. I don't want to take subsequent paragraphs out of context. Could we start on page 7 with paragraph 14? Key findings. This review found that prevent thresholds were generally well understood by the prevent practitioners who gave evidence to the review. Legislation, training, guidance and policies currently in place enable the prevent system to identify and offer interventions to people who may be susceptible to radicalisation. So that was the positives of the finding. Would you agree?
Yes.
But if we go down to paragraph 17, this review found that there may be too much focus among practitioners. Who are practitioners in this context?
So it would have been both prevent officers, but it would also include potentially those referring into prevent.
Yeah. So too much focus amongst practitioners on the presence of a terrorist ideology. Ideology is an important consideration, and practitioners, especially those who make decisions on progressing referrals such as counter-terrorism policing, should feel confident identifying it. However, as an early intervention programme, PREVENT must consider susceptibility to terrorist ideology or involvement rather than limiting PREVENT to cases where the terrorist ideology has already taken hold. And that clear indication in paragraph 17 that there may be too much focus still on terrorist ideology, that must be a matter of concern to you.
It certainly is, and that's why we're taking a range of steps to try to address that.
Over the page, please, if we may. Paragraph 18, please. Practitioners report an overall increase in referrals to PREVENT for violent young men who present with no ideology. And then these words, which has acutely accelerated since Southport. Can you help us to understand what you assess the cause of that acceleration since Southport to be?
Yeah, and I think this is slightly unclearly worded, actually, which I hadn't spotted before. But what we've seen post the Southport attack is a sharp increase in referrals to PREVENT, where there is where there are concerns about violence fixation. A sharp increase in concerns being flagged by PREVENT duty partners. What we are still determining is the extent to which this is the risk tolerance of other agencies having fallen, whether it's potentially an overreaction in some cases, or whether this is a larger cohort than we would have initially thought.
Right, so whether that is a previous underestimate of the cohort or a welcome improvement in referral rates is difficult to assess. Would you agree?
Yes, it is difficult. It is difficult to assess. I am pleased that we're getting this increase, and we have taken steps then to ensure that these cases do receive multi-agency case consideration.
Thank you. And then paragraph 21, please. The review found that both professionals and practitioners were sometimes unsure whether to refer or progress individuals fascinated with mass violence if they did not see a clear traditional extremist ideology. Now, the professionals who are unsure whether to refer, that seems to refer to outside professionals such as mental health professionals or teachers.
Yes, absolutely, and that's why the new guidance that we issued a few weeks ago was designed to be timed alongside school inset days so that we could make sure that teachers were aware of this particular risk.
I follow. But the practitioners who are unsure whether to progress individuals fascinated, is that a reference to counterterrorism officers and those involved in the channel process?
Yes.
And again, the fact that now in the autumn of 2025, this is the finding of this review, it is plainly very concerning, is it not?
Yes, it certainly is concerning.
Thank you. If we go to back to your reflections, please, page 51. So 51 of the statement, 4078. I'd taken you slightly out of turn to your paragraphs 173 and 174. In 172, again, candidly, you say this: strengthened training, guidance and resources is required to provide greater clarity to frontline professionals considering making referral and to CTP and channel panel members to support consistent decision-making. This should include resources on mental ill health, neurodiversity and radicalisation risks to ensure the professional judgment of practitioners is grounded in knowledge and expertise. It should also clearly stipulate that a case can be in Prevent as well as in other safeguarding services, as Prevent is the only programme that has the remit to assess susceptibility to terrorism. May I therefore invite you to include in the end of November update a full and detailed account of where has been reached in acting upon that alongside the other matters that I asked you to deal with earlier in your evidence.
Yes, sure.
Thank you. Turning to a completely different topic now, please, could we have page 53 of your statement on screen and paragraph 185. I'm turning to deal with youth diversion orders. You tell us that youth diversion orders are one of the measures that are being contemplated and due to be introduced through the Crime and Policing Bill 2024-2025. Is that right?
Yes.
And they are designed to tackle, be another part of the armoury for young people being drawn into terrorism. Specifically, is this right to disrupt young people involved in terrorist offending at an early stage and try to divert them away from the criminal justice system?
Yes.
It will, if I've understood it correctly, allow the police to apply to the youth or the magistrates' court for a youth diversion order, the age limit being if an individual is aged 21 or under.
Yes, that's right.
We should look, please, at paragraph 186. The requirements for this, if we can have the top of the page, please. No, we're page 55. Could we just have the top of page 55 highlighted, please, expanded? The technical requirements for this will be twofold. So first, the court must be satisfied to the civil standard of proof, not the criminal standard of proof, the balance of probabilities, that the individual has committed a terrorism or terrorism-connected offence, or that the individual has been involved in conduct likely to facilitate such an offence by them or another person. And secondly, the court must consider it necessary to make the youth diversion order for the purposes of protecting the public from a risk of terrorism or other serious harm. Those are the two-pronged test, yes?
Yes.
Now, I don't wish to be misunderstood, and plainly that is providing a further tool in the counter-terrorism toolkit. But pausing for a moment, in a case such as AR's, where there may be a fascination with violence, but there has not been or not yet been the commission of a terrorism or terrorism-connected offence, the youth diversion order wouldn't bite, would it?
No, it wouldn't. This is targeted at a slightly different cohort. It's attached to the terrorism definition, so we would be looking at that sort of more traditional pursuit cohort.
Yeah. So those who are interested in violence because of a fascination but without ideology, so are not interested in it for a terrorist ideology, and therefore it's not linked to a tact offence, are simply not going to be covered by these new orders.
No, they won't be.
One of the potential benefits, if we look please at the next paragraph, 187, is that amongst the things that can be done in the granting of a YDO would be restricting the use of specific websites or limiting association with specific individuals or groups. Is that right?
Yes, that's right.
Does the Home Office have a view on how to tackle that same area, that the use of the internet by youths, if they're violence-fascinated individuals, rather than traditional tact offenders in the making?
Yeah, and I think this is something that we recognise as a gap. We're doing some work at the moment, as I understand it, to look at other civil orders and whether there's additional changes that we need to other mechanisms that are out there. But I think as far as Prevent is concerned, we do a range of a sort of softer work, I guess, to try to disrupt the type of online activity that individuals might be involved in, whether that's through cyber interventions, whether it's through online safety training to parents, and whether it's through intervention providers working closely with individuals to help them understand the nature of their online interests.
Yes. So somebody like AR, if they consented or their parents consented to the Prevent process and they were taken on by Prevent, they would be receiving advice and education, encouragement to see the potential consequences of accessing this material online and education around the risks, yes?
Yes.
There might be support to parents in how to oversee that and prevent it and keep an eye on it, yes?
Yes.
And there might be steps taken with parents to encourage the sharing of information and use of firewalls and so on. But there are no powers that can be exercised in that situation other than with the consent of the parents.
Yes, none that I know of, yeah.
And does obviously there's a significant policy question about what might fill that gap and whether it's appropriate in terms of civil liberties and a number of other factors. But on the face of it, as I think you recognise, that is a gap.
Yes, it is a gap.
Again, for the November update, I think you indicate consideration is being given. I think the inquiry's interest for phase one and phase one reporting will be to have the best information available to inform report writing for phase one. So if that could be included in your November update.
Yep.
that takes us to online harms, which is a separate section of your statement. Could we just look at paragraph 151, please, on page 45? I think this is an area in general terms where a number of government departments have an involvement. Is that right?
Yes, that's right.
DCIT, I think, is another department that is involved. Is that right?
Yes.
And Ofcom has an involvement as well in terms of the Online Safety Act. Can you just help to explain what the Home Office's role is within this in terms of online harms?
Yeah, so the Home Office has the policy responsibility for harms, for a lot of harms which have an online element. So that might be violence against women and girls, child sexual exploitation, terrorism. So we look at this issue around that sort of wider policy responsibility.
And does that include extending to the difficult policy areas of whether more powers may be required to deal with harmful content?
Yeah, so it's the Department for Science, Innovation and Technology that are responsible for the Online Safety Act and the regulation of the internet, of online content. But yes, we certainly have views on this. We contribute to the thinking of it, and there may be certain measures that we would want to progress as part of that.
Thank you. You've set out in your statement work that is done, including by counter-terrorism police. So I think there's a paragraph 321, you explained that there's the counter-terrorism internet referral unit, which plays an important role in reporting potentially unlawful content to tech companies for their removal. Is that right?
Yes, that's right.
And you've mentioned the Online Safety Act and DCIT's role. Clearly, as a result of that, if we could just look at paragraph 322, please. That's page 89. So two aspects that you've set out. Online platforms must have systems and processes in place to identify and remove illegal content, but also to protect their users from the illegal content, including terrorism content. And then under B, from July 25 of this year, obviously got a lot of publicity, there's a requirement to prevent children from accessing various categories of harmful content, so that's harmful but not illegal, which includes serious violence content. Is that right?
That's right.
Plainly, if the material crosses the threshold and becomes something which is encouraging or inciting terrorist activity, it's illegal and the government has powers to require its removal, yes?
We can request social media companies to remove that material. What we don't have is a takedown power.
I think in relation to content that is terrorist related and is illegal as terrorist related, is there not a takedown power if it is in breach of terrorism legislation?
We don't have a formal takedown power of any description.
Aside from drawing it to the providers, the platform providers' attention and as harmful content, can we take a theoretical example? If there was something so grim as a beheading video, which wasn't as such in the associated wording on a website, it wasn't as such encouraging it, it wasn't relating it to terrorism, it just showed the most graphic, horrible act of a beheading. Is it right that that extreme violent material, even in relation to that, there's no government power to require it to be taken down?
Yes, at the moment, although that's under the Online Safety Act, that sort of content would be covered in the children's codes that came into that were launched in July.
Yeah.
But that would require that would mean no access for under 18s, although there are ways of circumventing that through things like virtual private networks.
And so indirect action, is this right, could be taken in relation to that against the platform provider if they were breaching the protection of children aspects in relation to that, yes?
That's right, Ofcom have a role.
But no takedown, even for that very extreme but non-terrorist, in a way, material?
No, we're not able to. We can request that companies remove content because it breaches their own terms of service, and we can explain that we believe it breaches TAC definitions, but we cannot compel the removal of material.
If we look, please, at paragraph 338, you say, it's page 93, after the sentencing of AR on the 24th of January of this year, the Home Secretary and the Secretary of State for Science, Innovation and Technology issued a joint letter to major social media companies and to industry leaders repeating a request made earlier in November for the removal of specific content that had been accessed by AR, as well as other material that had formed the basis of prosecutions under the Terrorism Act, including a request to remove the academic article on the military studies in the jihad against tyrants, the Al-Qaeda training manual. Is that right?
Yes.
And the graphic bystander footage of the stabbing of Bishop Mari Emmanuel, which it appears that AR searched for. To what extent has there been compliance with that request?
So, as I understand it, the military studies in the jihad, the AQ manual, has been certainly taken down by some companies. But others have made the argument that this is it's an academic study, and so therefore it touches into sort of freedom of expression. And on the graphic bystander footage, some companies again have removed it because they see it as being in line with their own terms of conditions, and other companies haven't.
What have X done on the latter?
They have maintained it, and in fact they brought a legal challenge against the Australian government, who had required its removal, and X won that legal challenge.
So despite the fact that it shows what may be thought to be an actual graphic bystander footage of a terrorist stabbing, X won't remove it?
Yeah.
And the British government, so far as that being accessed in the UK, has no power to require its removal?
No, it doesn't, although we can under the Children's Code. It is captured there as being sort of violent graphic footage, so there should be protection for under 18s.
Yes, unless the child is using a VPN.
Yes.
Is that a satisfactory state of affairs?
No.
Thank you. Can I turn now briefly to deal with the assistance you give in your statement around the legislative framework for sale, purchase and possession of certain other items. Could we look at paragraph 303 on page 85, please? The caster beans, which AR purchased, taking it shortly, it is the difficulty here that that plant is actually fairly widely used as for ornamental purposes, and therefore has a benign, reasonably everyday gardening use.
Yes.
And is it right that as a result of that, the sale of the seeds or the beans themselves is not in any way regulated?
That's right.
You tell us in paragraph 304 that the Home Office is in the early stages of working to consider the feasibility and potential impacts and proportionality of further regulation for that as part of the ongoing efforts to keep dangerous materials under review. Is that right?
Yes.
Are you able to give us a broad indication of the position reached on that?
That's still underway at the moment, so we're engaging with a wide range of trade organisations. We will be engaging with online retailers as well, but we're basically mapping the supply chain of castor beans in the UK, looking at things like packaging, the size of packages, and awareness of the risks of ricin amongst some of those sellers. That's a study that's underway at the moment. We expect it to conclude within the next few months, and then recommendations will go to ministers for looking at the broad sweep of what we can do against that, from all the way through from regulation through to working with different suppliers on a voluntary basis.
Thank you. May I, through the chair, please just invite you, not just in your November update, but by the sounds of it, that work may be progressing as this inquiry will need to be working on the phase 1 report. So would you keep the inquiry closely informed of
Yes.
The progress in that regard? Don't go into inappropriate detail, as I know that you won't, but will that also look at the potential for some systems to be engaged that look at items bought in combination? So you'll be aware that in a short space of time, AR, through the same platform, Amazon, bought not just the seeds, but also various pieces of chemical equipment, and indeed the isopropyl alcohol that was used to make the crude preparation of ricin. Will the review include algorithms that might be used to detect those patterns of purchases alongside ricin seeds?
Yeah, it'll look at the full range of options that we have.
Thank you. And then finally, in terms of other items that were purchased, we know, of course, that AR was involved in the purchase of a sledgehammer, and that's obviously not an age-restricted product, but he was also involved in the purchase of some smoke-emitting devices, smoke grenades, not in the military sense, as I know that you're aware. To your understanding, what was the legislative position? I know that this is not directly your area, but to your understanding, what was the broad legislative position in relation to those devices in terms of age requirements?
Yeah, so my understanding, and this is a lead for the Department for Business and Trade, but my understanding is that there are a few different, is that there is fireworks legislation that covers this, but in relation to these particular smoke grenades, it would have required the purchaser to be over 18.
So purchaser was meant to be over 18, but not, I think, is this right, a duty on online sellers to have any particular age verification process?
Not that I'm aware of.
And again, in relation to combinations of purchases, another aspect was the purchase of glass bottles, a jerry can, and we know that AR had matches affixed to them. You tell us in your statement that in the absence of an accelerant like petrol, that wasn't in itself an offence. Is that right?
Yes, that's right.
Does the work that you've indicated in relation to ricin, will that also cover the potential use of algorithms to do further work on concerning combinations of purchases such as that?
Yeah, I'm unsure, but I can certainly take that away and report back. I think the challenge with these particular items is that they're such everyday items, and it is the challenge of being able to put in place constraints that that are not easy for a determined attacker to work around.
Because glass bottles in themselves and matches in themselves, matters of that kind, obviously have, again, a benign everyday use.
Yes, and what we don't want to do is to put in place is to try to regulate for something when an individual can just go to a different hardware store or whatever. So there is a sort of a proportionality and a practicality challenge, I think, with these particular items, but I can provide further advice.
Thank you. So I'm just looking to my left. There were 3 sets received. I don't know if there are any questions.
Could I ask, please, just about the question of when 2 or more public authorities have a concern about an individual rising out of the same incident, for example, that in their view justifies a referral to prevent. Who should take the lead?
In terms of who...
Making the referral.
In terms of making the referral. So it doesn't matter, either can. And ideally, we would want them to work together to put together as full a referral as they can. Equally, both could refer.
Presumably, the guidance is that there should be a single referral in those circumstances?
So not necessarily. CT Police can receive both referrals from different parties and then consider that as a collective issue.
And if there is a single referral, presumably it's vital that the authorities share all their relevant information between them.
Yeah, and that's because of the data protection challenges and because different partners will have looked at that particular instance from a different perspective. Either way, we want that person referred into Prevent so that we can take an assessment of them and hopefully offer them support.
Because if that doesn't happen, there won't be an effective referral.
Yes, absolutely.
Where the concern arises out of police matters, so criminality or suspected criminality, would it be the expectation that the police would take the lead?
In terms of a referral into
Yes.
Prevent? So yes, police, local policing refer into Prevent frequently. So yes, we would expect them to refer in and to work closely with CT Police colleagues to share their concerns.
And I say that because the police would have ready access to critical intelligence. Is that right?
Yes, they might do.
And they are skilled at presenting and gathering evidence.
Yes, but equally, sort of teachers, healthcare practitioners, anyone that is subject to the Prevent duty should have the skills they need to make an appropriate and well-informed referral into Prevent.
But does it follow, though, that when the police make a referral for the reasons I've suggested, that will necessarily be a more weighty referral and be received as such?
I'm not sure that CT Police necessarily consider where the referral has originated. I think the key is making sure that there is lots of information within that referral and that it clearly sets out the risks. For us, we tend to find that the best referrals come in from the person that knows that individual the best. That can often be a teacher, it can often be a mental health practitioner that's working with an individual, or indeed it could be a police officer.
But typically, a police-led referral would concern criminal matters, which by its nature is more weighty, isn't it?
If there is a violence concern as part of that, then I would imagine that is something that CT Police consider when they assess that referral.
And the other factor, I suppose, is that this is a referral coming from colleagues who work like them.
Yes, potentially.
New topic, you discussed briefly with counsel to the inquiry about engagement with Channel. Am I right in saying that the level of engagement is around about 75%?
So the level of consent is around 75%, yes.
Yeah. On the face of it, quite a high level of consent for people who are suspected of being radicalised or being drawn into terrorism. Would you agree?
Yes, I agree.
No doubt you'd wish it to be higher?
Yes, I would love it to be 100%, but we can't have everything.
But the officers on the ground are presumably quite skilled in getting that consent.
So that consent will come from whoever is the most appropriate professional to approach that individual. So that might be a local authority, it might be a teacher, or it might be a mental health practitioner, or indeed it might be a police officer. But yes.
When it concerns a young child or a young teenager, the support of the parents is presumably vital to get that consent.
Yes, we would require parental consent or guardian.
But overall, on a referral to Channel, your expectation is more likely than not that they will engage and offer their consent.
Yes, in my experience, that they would consent, and then usually people engage.
Failing that, I think that the route is a police-led partnership.
Yes, that's right. So if police consider the risk to be too high for Channel, or if they haven't got consent but police identify a concerning counter-terrorism risk, then yes, they can be managed through police-led partnerships.
And presumably when there's been a failure to consent and a referral to a police-led partnership, the risk is higher. Often
police will manage cases of the very highest risk within police-led partnerships.
Yeah. Higher than, for example, if the route had been immediately to a police-led partnership at an earlier stage. Is that right?
So I think it just depends on the facts of the case and the information that the police have in front of them.
In any event, the message would be passed back to the police-led partnership, which is a multi-agency type of arrangement, that this had happened and this is our view about the risk.
Yes, so that's what would normally happen if that case had made it through the Prevent Gateway assessment and is then considered in more detail by police-led partnerships. Then yes, there will be multi-agency partners that are involved in sharing information on that particular individual.
Thank you. Thanks.
Thank you very much.
Ms. Elsmore, we've covered a lot of ground. Is there anything that you wanted to add?
No, thank you.
Sorry.
Just one thing from me, Ms. Elsmore, if I may. When Mr. Moss was asking you about the potential for other civil orders, and this was in the context, I think, you raised of the particular involvement of the Department for Science and Innovation and Technology, you said in an entirely understandable way that there may be certain measures that you would like to progress. Can you, when you report back during November, be rather more specific than that as to what is in mind? And can I make it clear in this context, which strays a bit outside of your terms of reference, but undoubtedly touch on them, that I have a particular interest in and concern about those in AR's position who, in relation to whom there are potentially strong grounds for believing that they have an interest in committing really serious violence, but they have done nothing that constitutes a criminal offence for which they could be arrested and in relation to which other powers could be exercised, such as search, and whether in highly restricted circumstances there are, and when a high burden of proof has been, or a high-ish burden of proof has been satisfied, whether there should be the opportunity for a court to impose certain restrictions on what that individual does and is permitted to do. So I would be very grateful if I could have some indication as to whether anything along those lines has been the subject of consideration, whether it is actively under consideration, or whether it is one of the things that is being considered in the pipeline.
Yeah, so we are looking at sort of civil orders. What we're also looking at is the Jonathan Hall KC recommendation that of a new offence around the preparation of a mass casualty attack that isn't connected under TACT legislation. I wonder whether there's something there.
I understand the recommendation by Jonathan Hall. It is, although linked, very much separate from what I'm focusing on at the moment, which is not where a criminal offence hasn't been committed, and where one isn't looking to create another criminal offence, but you're looking at a member of our society who historically you may have the gravest concerns that they are going to go out and commit an offence, but they haven't done anything that would justify their arrest and prosecution. Now, historically, in this country, we have said we will do everything we can to stop that offence, and we will keep our eyes on them. I am interested in whether we ought to be thinking about, or not, having the ability to impose certain restrictions that fall short of imprisoning that individual.
Okay.
Does that make sense?
That makes sense. I'm not familiar with any work, but I will take that away.
I'd just be interested to know whether behind the scenes and beyond my purview that has been considered, because if it has been considered, I would very much like to see what the fruits are of any thought that's been given to that issue.
I'll revert.
I'm very grateful to your assistance, Ms. Elsmore. You're now free to go. Thank you very much.
So with your permission, I'm afraid Mr. Boyle will call DCS Kenwright, and we might take 20 minutes or so of her evidence before the mid-afternoon break.
Certainly, Mr. Mills, thank you very much. Pause just for a moment while some rather loud heels. Yes, could you take the oath, please?
I do solemnly, sincerely and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth and nothing but the truth.
Thank you very much. Please have a seat. Can I ask, please, that in future, when a witness is taking the oath, people aren't either coming into or leaving this room? It's entirely inappropriate. Yes, Mr. Booth.
Detective Chief Superintendent, can you give your full name, please?
Yes, Sarah Kenwright.
Thank you. Could we have up on screen, please, CTP NW 30169? Thank you. And if we go over the page. Sorry, keep going through the index. Thank you. Do you recognise that document as your witness statement?
I do, yes.
Thank you. We saw the date was the 8th of August 2025.
Yes,
Thank you. And is that true to the best of your knowledge and belief?
it is.
Could we also please have up CTP NW 4047? This is a chronology which is prepared, I think, not by you specifically, but on behalf of CTP Northwest. Again, are you able to confirm that that's true to the best of your knowledge and belief?
It is, yes.
Thank you. DCS Kenwright, I want to start by asking you, please, about your role and background. Is this right? You're a Merseyside police officer seconded to Greater Manchester Police in your role as head of CTP Northwest.
Yes, that's correct.
You started your policing career in August 2001 and have conducted various roles in uniform policing, investigations and intelligence.
Yes,
You were Detective Chief Inspector of Merseyside Special Branch from January 2016 to November 2017 and Head of Intelligence for CTP Northwest until January 2020 when you returned to Merseyside Police. Is that right?
that's correct.
You've been head of CTP Northwest since the 5th of December 2022. Could you give us a short summary of what that role entails?
Yes, so as the head of CT Police in North West, I am responsible for delivering across the 4 Ps of pursue, prevent, protect and prepare on behalf of the Chief Constables within the North West region, which constitutes Cumbria, Lancashire, Greater Manchester, Merseyside and Cheshire.
Thank you. You tell us that you're also the Intelligence Capability Lead for CTP. What does that involve?
Yes, so I chair the Intelligence Capability Board, which is where we consider a national level intelligence process, policy and procedure. We try and drive consistency and deliver against organisational learning and engage with other capabilities to ensure that we have a joined up approach across CT policing.
Thank you. Just to come on now to the structure of CT policing, it's a network of operational units based in separate regions around the UK, correct?
Yes.
And we'll hear from DAC Evans, that CTP HQ provides coordination and governance over the regional CTP units, is that right?
Yes.
And CTP Northwest was set up in 2007. What is its host force?
Its host force is Greater Manchester.
Thank you. And I think you've set out the regions that CTP Northwest works in, but I think for our purposes that includes Merseyside Police and Lancashire Constabulary, correct?
It does, yes.
Thank you. You mentioned the 4 Ps, so the 4 strands of the contest strategy. From the perspective of pursue, in short, what is the work of CTP Northwest?
So the work of CTP Northwest in Pursue is mainly around the investigative capacity and anything that meets the CT threshold that I appreciate has been discussed by previous witnesses. That is a combination of intelligence and investigative units.
So investigative units and intelligence, does that include the Fixed Intelligence Management Unit or the FIMU?
It does, yes.
And you tell us at your paragraph 2.22 that the FIMU is responsible for the receipt and assessment of all intelligence entering the CT network, is that
yes.
right? And in Lancashire, the FIMU was co-located with Lancashire Prevent officers, is that right?
Yes, I believe so. I think many years ago they were actually in different locations, but they are now under the same roof, yes.
And we'll come on to the role of the FIMU in prevent referrals shortly, but just moving to CTP Northwest and prevent in general terms, I think we've heard that there were 3 geographical hubs or locations to deliver prevent in CTP Northwest, correct?
Yes.
Thank you. And obviously we've heard from PC Thompson as a CTCO and DS Trahan as a CTCO supervisor. Above them, there was a line management structure which went up to inspector, is that right?
Yes, for the
hub. And then there's a senior responsible officer as well, is that correct?
Yes, there was a regional prevent coordinator and an SRO at superintendent level.
Thank you. In addition, there was the vulnerability support hub, which I think you tell us was located with the prevent team in Manchester and Leeds at your paragraph 2.15. Was that support hub part of CTP Northwest?
We were part of a pilot, I believe, in relation to vulnerability support hubs. Certainly now, under its new title as the Clinical Consultancy Service, it's actually directed and controlled nationally through CT Policing headquarters, but they remain situated with us in Manchester.
Thank you. And that was a kind of clinical consultancy service and mental health team, is that right?
Yes.
Can I just go through the process of a prevent referral from the CTP perspective? We've heard evidence about this, but I just want to focus on 1 or 2 points. I said I would pick up on the role of the FIMU in prevent. The first step after referral is made is that it comes to the FIMU for deconfliction. Can you just explain what deconfliction is?
Yes, it's basically just to ensure that an individual isn't already part of a CT investigation.
And in those circumstances, you wouldn't want to be running the normal prevent structure for risk of potentially compromising the criminal investigation. Is that right?
Yes, but if there are any prominent safeguarding concerns, we would still look to address those.
And in certain circumstances, we've heard that there would be a consideration by the Joint Assessment Team or JAT with MI5 officers at this stage.
Yes.
Is that right? Thank you. Once that process is completed, a referral will be assigned to a CTCO to make a prevent gateway assessment, correct?
Correct.
And the test that they would be applying is reasonable grounds to suspect that a person is susceptible to becoming a terrorist or supporting terrorism. Is that correct?
To conduct the prevent gateway assessment, yes. They would then have to meet the Section 36 decision threshold, which would take them to reasonable grounds to believe.
Thank you. So taking this by steps, if that test was satisfied, then the referral would progress to the information gathering stage. Is that right?
Yes.
Sorry, the reasonable grounds to suspect test at the gateway assessment was passed. You would then move to information gathering. Is that right?
So as I understand it, they would need reasonable grounds to suspect to conduct the prevent gateway assessment, but when they got to the end of that gateway assessment, they would have to make the Section 36 decision, and that threshold decision is reasonable grounds to believe. They would then have to make a decision in terms of whether channel or PLP was the most appropriate route for that case and why.
Yeah, but I think before getting to the reasonable grounds to believe, would there not have been an information gathering stage where a channel coordinator a channel coordinator would carry out information gathering?
It would go to information gathering post that Section 36 decision.
I think we've seen some diagrams which would seem to show that the reasonable grounds to suspect decision comes first. The case then goes to the information gathering, which in dovetail would be determined by a channel coordinator. And then after that, the Section 36 decision would be made. Are you able to help on that?
The Section 36 decision lies with the CTCO.
Yeah.
So they have to make that decision in terms of whether they believe it is suitable for channel.
So I think my understanding is that, and the evidence we've heard is that where dovetail is in place, the reasonable grounds to suspect decision would be made. If that was found to be met, the case would then go to information gathering with a channel coordinator, and then after that, it would go back to the CTCO to make the Section 36 decision of a reasonable belief that a person is vulnerable to being drawn into terrorism. Does that sound correct?
Would it help if I looked at the diagram or?
Yes, I think we are getting it.
Okay.
Sarah, sorry, we'll have to pull up this. I hope that it's on the system. It's CTPHQ 30117. And we're looking at page 38. So if we could zoom in on the middle box of that screen, the beige, the box above the beige, and the three boxes below it. So just zoom the center of that page, please. Above the the beige area, do you see we have the gateway assessments?
Yes, I see, yes.
Yeah. And then below that, we have information gathering. So ensure legal grounds for sharing are met, and then conduct sharing or information gathering. And then do you see below there it says within 20 working days, section 36?
I do, yes, yes.
So I think within Dovetail, that information gathering stage was done by a channel coordinator, is that right?
In Dovetail it was, yes.
And after that section 36 decision of whether there's a reasonable belief that the person is vulnerable to being drawn into terrorism, the case then goes to the channel panel, and is this right? The channel panel then decides whether or not to accept the referral.
Yes, they do.
Thank you. Could we have up, please, CTP HQ 40s? Uh, 45. And page 8. And if we could just enlarge that. So we have the dovetail diagram here. And do you see in the bottom left, we have the police conduct initial screening and assessment of the case.
I do, yes.
Passes initial screening and police have suspicion of a vulnerability to radicalisation, which requires further consideration by multi-agency channel.
Yes.
And then we see it moves across under a yes to dovetail cases under that local authority. I think that must be.
I do see
Then
that.
the second box on the right-hand side, local authority gathers information from all relevant partners. And then sufficient information for consideration to be adopted by panel. The section 36 decision comes below that, and that's made by the police. Is that right?
Yes, the section 36 decision always lies with the CTCO, whether that was in dovetail or not.
Yeah. But is it right that in dovetail there was a sort of intermediate stage where the case went to the local authority to carry out information gathering?
I believe so, yes.
We can see that these diagrams are reasonably complicated and have quite a lot of stages. Do I take from your answers a little bit of uncertainty about the information gathering stage in Dovetail Pilot?
Well, I was never a CTCO at the time, sir, so I am referring to the documents as you are in terms of trying to work through those cases. But yes, they are complex in terms of the number of steps that there are.
Having had to work through those documents as we just have, do you agree that it is quite difficult to keep track of the many decision points that a referral needs to go through?
Yes, I think CTCOs have a difficult job to navigate that.
Well, that was my next question. Did you have experience of CTCOs having difficulty with it?
I wouldn't say difficulty. I think that their experience and professional judgment is critical in terms of their decision making, and I think we heard from PC Thompson in relation to that in terms of taking on her prior experience and how she would utilise her peers and her supervision to help her make the right decision.
We've got this added sort of switch of the case or passing of the case from the CTCO to the local authority and then back again between the gateway assessment and the section 36 decision. It's been suggested in reviews that that might have added a level of friction, or there might have been a reluctance from CTP perspective to move to information gathering and pass the case on to the channel coordinator. Were you aware of that at any time?
No, I wasn't, and I think from listening to the CT Police in North West witnesses, I think they have described that it didn't, that friction I don't think was there from their perspective. And there is some evidence that points to it working quite well in the Northwest, and that the pilot went very well. There were some really good aspects to it, and Lord Anderson actually makes reference to the Northwest putting the highest number of mixed, unclear, unstable ideology cases through to Channel whilst that dovetail pilot was in place. So there were some really good aspects to it.
Thank you. So I think at your paragraph 8.59, we don't need to bring it up, but you say a substantial proportion of cases were being referred into Channel through the dovetail process. So you don't view that as a kind of barrier, at least in the Northwest?
No, I think it was just a change in who was responsible for a certain aspect of that process. I don't think it necessarily caused friction as such.
Thank you. We might just come back to this in the context of the visit, but I'll leave that to the chronology. Next, policies and training. CTCOs and I think CTO supervisors were required to complete the National Prevent Foundation course, which was a week-long national course. Is that right?
Yes.
And I think the expectation was that it would be undertaken within 6 months of starting the role. Is that correct?
I believe so, yes.
So we heard, I think, from both PC Thompson and DS Trahan that it took them a bit of time to undertake the course. Given it's a week-long course, I assume that it can only be run on a set number of dates. But have you ever had any cause for concern that there are CTOs working before they have completed the course?
Certainly not now. It's my experience and understanding now that CTCOs have to complete a series of modules of training and an assessment before they are able to carry live casework, appreciating that it was different at the relevant time, but that is certainly an improvement that has been made since.
Moving to the FIMU staff, is this right? They're trained on the National Standards for Intelligence Management?
NSIM, yes, they are.
NSIM, yeah. And that, as the name suggests, I assume, is a national training module. Is that right?
Yes, it is.
Thank you. That involved an element of training about Prevent. Is that right?
Yes.
But I think we heard from Officer B that he couldn't recall receiving specific training on Prevent. And he accepted, I think, that he didn't have a deep knowledge of how Prevent functioned. And I think DC Blundell's evidence was that he was basically trained on Pursue and not Prevent. Their evidence might suggest that at least back in 2019 to 2022, FIMU officers weren't sufficiently trained in understanding Prevent. Do you agree?
Not entirely, no, because I think the training that they did get allowed them to have an understanding of what Prevent were there to do, and that might not have given them a deep knowledge of the role, but I think they understood the Prevent function, and I think some of that came across in their evidence in terms of their understanding of the different threshold as well.
We might come back to that. And what about local training? Was CTP Northwest delivering its own training to CTCOs and also on the FIMU side?
So CT Police in Northwest would effectively ensure that officers and staff received the relevant essential training for individuals to conduct their roles, but that essential training would be a national product. We would deliver other training in CPD alongside that. So, for instance, when an individual starts within CT Policing Northwest, they would have an introduction to CT course, which teaches them the basics about CT, the network, the 4 Ps and what our responsibilities are. So it was a blended approach between national courses that are delivered from the ODU, the Organisational Development Unit, and added extras, if you like, that CT Police in Northwest would do to help people settle within their role.
We heard from DS Trahan that she hadn't had an induction as a supervisor. Do you agree that that should have been in place at the time that she started?
I think that an induction process is always useful. I don't know whether there's been any assumption that because of her past experience that wasn't necessary. What I would say is that supervisors or anybody that has gotten a promotion through policing will be part of wider leadership programmes through their home force as well to help them adjust to the new rank.
But it doesn't seem that had happened for DS Trahan. Are the systems in the CTP Northwest prevent structure to ensure that supervisors are trained and inducted?
Yes, absolutely. We need to make sure that we give our officers and staff the skills to do their job. And I think DS Trahan had some background which meant that she didn't get some of that straight away. She did have the ability to reach into her supervisors and to her peers while she was awaiting those courses, but certainly she may have had other training in relation to being a sergeant from her home force.
Understood. So she might have had a level of training about supervision and line management.
Yes.
What role does CTP Northwest have in setting of policies for Prevent?
So we don't set the policies as such because it's really important that from a CT policing perspective we have that consistency across the network so that there's not effectively a postcode lottery, if you like, of how we are delivering. So the policies are national.
Does CTP Northwest input into the policies that are set by the Home Office and CTPHQ?
CTPHQ certainly engages regularly in terms of the consultation process when policies are changing so that we're able to feed back, yes.
Because presumably CTP Northwest has the experience of how the CTCOs are applying the policies. And so you've got that expertise to assist in a consultation, is that right?
We try, but we utilise the practitioners to contribute to that as well. It's important that whatever policies are being introduced, that they work at a practical level for CTCOs and others.
Thank you. Could we have your statement up, please, at page 10, paragraph 3.3? Thank you. If we could just zoom to the last paragraph. So you helpfully set out in your statement the policies and guidelines that applied and or were updated during the relevant period. And the first is the Prevent Practitioners Policy. Can we go over the page, please? Thank you. We then had the Prevent Policy, which was updated in 2020 to reflect changes since 2018. We had the CTCO guide used in conjunction with the Prevent Policy. When was that published? Do you know?
The CTCO guide, I think, was 2020 as well.
Yeah. Below that, we have the Channel Duty Guidance. Is this right? That's aimed at a slightly different audience in that it's focused to the members of Channel Panel and partners of local panels.
Yes, I believe
Correct?
so.
Yeah. Whereas the first three, I think, would have been aimed at CTCOs in particular and their supervisors.
Yes.
Yeah. The Prevent Gateway Assessment Guidance, that would be guidance to assist a CTCO, is that right?
Yes.
And the same is true of the Dynamic Investigation Framework, 2019. How did all these policies fit together for a CTCO?
I think when you see it all laid out on a page like that, it is a lot. But I think that they worked as a team to navigate that in a professional way, to make sure that they directed individuals through the system to the right relevant outcome.
So we see quite a few policies on the page. Is it right that some of these were quite frequently updated?
Yes, I believe so.
So just to give example for your notes, the policy for prevent practitioners in August 2020, which is CTP HQ 30117, was version 3.5. And the Counter-Terrorism Case Officers Guide, dated the 7th of December 2020, was version 3.7 at CTP HQ 000115.
Thank you.
Were some of these policies, so for example the CTCO Guide, the Prevent Policy and the Prevent Practitioners Policy, overlapping?
I think they were meant to complement each other. So I believe the CTCO Guide was to complement the Prevent Policy and to be used, I think, as a toolkit effectively of how the CTCO was meant to apply the Prevent Policy.
And was it difficult for CTCOs to try and keep up with all of these policies?
Again, I feel like I'm speaking for them here because I wasn't a CTCO at the time, but I think when you look at it holistically, it does look like a lot, and we'll be very reliant upon CTPHQ as well as the managers that we have within Prevent to help staff understand and embed those changes.
What could CTP Northwest itself do to ensure that CTCOs could keep up with all of this policy?
So we can look at it from a supervision perspective. So as a CT head, I'm reliant upon the supervisors and managers within Prevent to dip, sample and quality assure the work that goes on within that area of business, to both support the CTCOs but to ensure that we are adhering to policy and process.
I want to move on, please, to the first Prevent referral, and I'm going to try to do it in themes rather than chronologically.
Okay.
The first theme is the role of the FIMU and the JAT and how they work together with Prevent officers. We'll come on to ideology and the joint letter, but can I summarise it in this way, that the joint letter effectively cast the net wider for Prevent in terms of what was relevant to them than was relevant for the FIMU?
Yes, that's correct.
So the scope of Prevent relevant was wider than matters that the FIMU would be looking at for their own assessment.
I think that wasn't just down to the joint letter. I think that was articulated in policy too.
Yeah, so I think we heard from Ms. Eldersmore that the joint letter wasn't the start of this, but it was perhaps one example. Just to break that down, school massacre ideology, for example, was Prevent relevant, but it wouldn't have been the sort of political or religious ideology that would have sustained a prosecution under terrorism legislation. Is that right?
That's correct, yes.
Thank you. And the same would be true for violence fascination. Is that right?
Yes, that's correct.
Thank you. Could we have on screen, please, CTP HQ 4042? We see here, I think, an annex to the NSIM that we've covered before, which was the FIMU, FIMU guidance, correct?
That's correct, yes.
Thank you. Could we have, please, page 3? And could we enlarge section 4? So, in the important box, we see case reviews have identified multiple occasions in which cases suitable for Prevent have not reached local teams due to a RADO 6 outcome, no CTDE relevance during the IMU assessment. Where intelligence has been submitted directly to an IMU or come through a route in which the local prevent team were unsighted, they've been left unaware of such cases. Is what is being addressed here the failure of the FIMU to pass on a case to prevent?
That is how it reads, and they have assessed on CTD relevance, but it appears that they haven't taken into consideration the different prevent threshold. And this document was to enforce them considering the different prevent threshold.
So it's perhaps a slightly different issue than the one that we've seen in the evidence that we've heard. This is intelligence that has come in that is not a prevent referral, has been analysed by the FIMU, and the FIMU hasn't appreciated that it ought to be passed on to prevent where it's RADO 6. Is that right?
It sounds like from case reviews, so that there's either been an audit process or potentially through organisational learning that's taken place from other reviews or inquiries, that there may have been some missed opportunities. I believe that section has been put in this document to reinforce the different relevancy thresholds that the FIMU and the prevent teams work to.
Yeah, so perhaps if we look at the last paragraph, we see that there most clearly. Cases assessed as RADO 6, so that's no CTDE relevance. Local prevent teams may consider cases assessed as RADO 6 as CTDE relevant for the purposes of prevent, and such cases may still be managed within that team. Looking at this now, is this language, do you think, straightforward for FIMU officers to understand?
I think they understand it, but I would say that we're at the point where we recognise that it needs updating. So CTD relevance it's a legacy term, I would say, within CT policing that we've been used to for a long time. And I know that you want to touch upon what has changed and what recommendations will come as part of this inquiry, but NSIM is already under review, and that will look at the language that's utilised within it around that relevancy, the RADO outcomes, and updating CTD relevance.
So the confusing thing about this might be that the idea that CTDE relevant means something different to FIMU officers and prevent officers?
I don't think it means something different. I think they both understand what that CTD relevance is, and they recognise that that is the pursue threshold. They understand that. I think this document has just been enforcing with intelligence assessors that they understand that that isn't the only relevancy threshold that they need to apply to a case, and that RADO 6 can have an interest for prevent teams still.
Does the use here of the phrase in the second line of the last paragraph, CTDE relevant for the purposes of prevent, isn't that likely to cause confusion?
Yes. Yeah, I accept that. And as I say, the NSIM document in its entirety is being reviewed. So it's not about CTD relevancy for the purposes of prevent, it's relevancy for the purposes of prevent, I would suggest.
Thank you. I just want to come on to some examples. First, I think we heard in the evidence of DS Trahan that she'd said that she'd effectively taken issue with FIMU staff overreaching into prevent decisions. Did you hear that evidence?
I did, yes.
Thank you. Could we have up on screen, please, LANC 30175? And page 137. If we could just zoom into the text there. This was the email from Officer B of the FIMU to the CTCOs following the JAT assessment. And the second line of that is, this has been returned, I think that should be from the JAT, for a prevent referral to be inputted on the PCM channel and referral to channel/dovetail. The root of this, I think, was the JAT assessment by DC Blundell himself.
Yes.
I think he accepted that his reasoning could have been better worded, but I don't think he was intending to mandate an outcome. That was his evidence, wasn't it?
Yes, that's correct. He wasn't intending that.
The way Officer B has translated this does read, doesn't it, of a FIMU officer trying to decide the outcome of the gateway assessment.
I appreciate that it could be read like that, but from the evidence, both from the prevent officers and from the FIMU officers, I think showed that they understood that prevent would conduct their own assessment, that was their decision to make.
So that was the evidence that was given now, but on a plain reading of the email, doesn't it seem to mandate the requirement?
I don't think it seems to mandate it. I think it's the way it reads, which I appreciate isn't ideal. But I don't think there was ever any intention either by the FIMU for them to mandate that on behalf of Prevent, or that Prevent felt that they had to do that. They understood that the decision was theirs.
Is referral to channel/dovetail open to interpretation?
It is objectively, yes, when you sit and read it without the rationale that's given by the officers that had involvement in the case.
So there are a few more examples of this, but I think now is probably a good moment to take a break.
10, 15 minutes? How long, Mr. Boyle?
15 minutes, please.
Certainly. We'll sit again at 25.
Thank you. So thank you. We had some technical teething problems. DCS Kenwright, we were going through the FIMU language and the role of the FIMU. Can we have up another document to look at this, please, which is CTPHQ 4087. So this is, I think, an action report from the system NCIA, is that right?
Yes, that's correct.
When we look at the middle of the page and we see title and then text, does that text prevent officers attend the Emergency Child Protection Conference, etc.? Is that the action in question?
Yes.
Thank you. So the action is attend the conference, JAT assessment to link in, consideration for channel dovetail and recording on PCM tracker, establish why AR has been searching school shootings. If we then please look down to about 6 lines from the bottom of the penultimate box, please can you advise if this can now be closed to prevent many thanks? I think that's a note from PC Thompson. I think PC Thompson said that she understood the distinction between the roles of the FIMU and Prevent and her here, and that I think she was referring to could the action be closed, is that right?
Yes.
Yeah. Do you accept that closed to Prevent could be confusing on a plain reading of that language?
Potentially, but it is on the action itself and is being recorded as an action result. But I understand that it could be perceived differently.
Yeah. So we see Officer B's response below. The above has been reviewed and can now be closed in relation to the incidents at school. This is being dealt with by Merseyside Police, who have taken the matters to CPS, and the subject is excluded from school and is open to social services. Officer B says the above has been reviewed and can now be closed, but provides quite a lot of further rationale for that, which might be thought to relate more generally to the prevent referral. Would you agree?
I would suggest not, because it's on the NCIA system. So if it was on the prevent case management system, I would agree with you, but this is on NCIA in terms of the FIMU tracking that referral and the action through the system, if you like.
Would you agree that on a plain reading of the wording, it looks as if Officer B is directing for the prevent referral to be closed?
I don't believe he is, and I don't believe he said he was in his evidence either.
Yes, that's right, although I think that was tested in questioning as to whether on a plain reading that is what this actually showed, regardless as to what he said his understanding was at the time he gave evidence.
He's reviewing the action and assessing whether the action can be closed, but he's not saying close the case on PCMT.
Do you accept that the language here could have been clearer?
I think that it was understood by the FIMU officer and by the prevent officer in terms of they were trying to deal with the action that was sat on NCIA, and for that action to be resulted in terms of what it said in the action box. I don't believe that they were trying to direct what happened on PCMT as such.
Can we take things slightly out of order and just look at some messages around the second referral, CTP Northwest 30140? So we have here, I think, Officer A's assessment of the second referral. And I think if we go to page 2, and if we could enlarge the writing in red, we see the analysis at the bottom of the page about the referral, and then as such, I do not believe this new intelligence is worthy of a new prevent referral, as I do not assess it would meet the threshold for adoption at, I think that should be at channel, and the content does not suggest he holds any extremist ideology, but rather an opposing opinion on Gaddafi's Libyan regime. Do you agree that Officer A overreaches his role as a FIMU officer in the analysis that's been given here?
I appreciate that it can be perceived as that, but I will go back to the officer's evidence, both from the FIMU and the prevent perspective, in terms of them understanding the different thresholds that they're working to. There is an expectation that FIMU officers understand prevent work, and whilst they are making some commentary in relation to prevent, they still understand that prevent in their own right have to make a decision in terms of their own threshold.
So, I mean, we've got a statement from Officer A. We haven't heard him give evidence, and I think you're right in the statement. He says that he understands the distinction, but it's quite clear on the plain language used here that he doesn't, isn't it?
I don't think it says that he doesn't. He's trying to express a view, and even in the CTCO guidance, it makes reference to the point that FIMU officers have to have an understanding and to be able to express an opinion in terms of prevent, but that the decision is not theirs, that it's the CTCO's.
But he doesn't just say new intelligence isn't worthy of a prevent referral. He goes on to say it wouldn't meet the threshold for adoption at channel. That's purely a decision for the CTCO, isn't it?
Absolutely, yes.
Yeah. So this is then an overreach, isn't it?
It could be perceived as that, and if there's any learning that can be taken in terms of how FIMU officers are expressing themselves on records, we'll absolutely take it. I think the importance is that the CTCO still understood that they had that decision in their own right, and the FIMU expected them to do that as well.
So I understand, DCS Kenwright, the understanding and the expectation on the officers, but don't these documents, or at least this document, show that that understanding and expectation wasn't actually there?
I think the understanding was there. I accept that maybe it can be worded more clearly in terms of the recommendation to prevent, but I think the understanding was there.
Could we have up page 36 of your statement, paragraph 8.5? So you're addressing, I think, in response to issues being taken with the language used by the FIMU. And you've done an analysis of the matters that have been raised in the review. And you say at 8.5, I agree the use of language by FIMU assessors is a point of concern, and we'll be taking this forward to ensure consistent practice across the team. Is it your analysis that this was just an issue of language and not one of understanding?
Yes, I believe it's an issue of language because it didn't impact on the CTCO's decision making.
But I'm actually talking about the understanding of FIMU officers and how familiar they were with PREVENT. Would you agree that there's a number of examples that we've seen of what might be said to be unclear language?
I accept that there is some contentious points in relation to how that language is utilised and how it can be perceived when it's taken out of context and without the explanation, I suppose, of the relevant officers. I think it's important for them to understand how it can be perceived and to take learning from what this inquiry is drawing out in relation to that, absolutely. I think training from a FIMU perspective has developed and improved over time, and I know that you've made previous reference to the PowerPoint slides that FIMU officers, that intelligence assessors now get, which is quite detailed in relation to that role of PREVENT. So it's been an evolution over time, I think, in terms of them understanding how they work best together and how they complement each other. I don't think it affects the decision making, but I think if there's anything that we can take from this in relation to how they are wording it so that it's absolutely clear in terms of that handover of responsibility, then we will.
Moving on, please, to the school browsing history. We've heard evidence about liaison between the ACON school and the FIMU in relation to this. I'm going to try and summarise it without pulling up the documents and statements. Tell me if this is not a fair summary. We cannot be sure exactly what was sent by the school alongside the referral form on the 5th of December 2019 because the way the emails have been retrieved means we can't see how many were sent or cannot be sure how many were sent. Do you agree?
Yes.
The attachments that can be identified do not include the school browsing history, correct?
Correct.
Officer A referred to a large dump of data being received, and Officer B made contact with the school and asked for specific concerns to be identified.
Yes.
Later requests were made by Officer B for the school browsing history. So it's clear, I think, at that time that he did not think that it had been received.
Yes, that's correct.
And Officer B recorded a response from the ACORNs to that, which wasn't, it's already been sent, but instead will be contacting the school IT provider to obtain this information if it's still available.
Yes, that's correct.
Thank you. Regardless as to whether that was sent, PC Thompson accepted that between the FIMU herself and the school, it should have been obtained and considered by her. Is that right?
I think it would have been useful before the case was closed for PC Thompson to have tried to obtain anything that was available, yes.
Yeah. So if the school hadn't provided it, it should have been chased, shouldn't it?
Yes, ideally. And I appreciate that DC Murphy was also trying to get hold of that information from a Merseyside police perspective as well.
PC Thompson said that the fact that AR, who I think was 13 years old at this stage, was searching for images of gory and unpleasant degloving injuries raised the level of concern significantly and would have led to a referral to Channel. Did you hear that evidence?
I did hear her say that, yes.
She said that was on the basis that it was consistent with a fascination with unpleasant injury, and it also would have impacted on the reliability of what AR was saying, and we'll come back to that latter point. It might be added that it would be concerning that he was doing this at school and raise a question as to what he was viewing in the privacy of his own home. Do you agree?
Potentially, yes.
You mentioned DC Murphy. PC Thompson knew that AR's devices had been seized by the Merseyside Police criminal investigation, correct?
Yes.
And in those circumstances, she could have linked in with the criminal investigation to discuss the review of those devices, couldn't she?
She could have, although DC Murphy, I believe, said that she was going to let us know if there was anything that was pertinent in relation to those device downloads. But I accept that, again, a follow-up in relation to that outstanding action would have been useful.
So I don't think I've given the reference for this, but we have the forensics report of the devices, which is now on our workspace. It's MERP 208359. And at page 115, we can see searches were done for the name of the victim, teachers, the name of the school, as well as the words shooting and beheading. So I don't propose to pull that up.
Fine.
I give you
very much.
The referral was closed without knowing the outcome of that review or the scope of the review. That's right, isn't it?
I believe so, yes. I don't think PC Thompson was aware of the scope.
Yeah. Could we have up, please, page 42 of your statement at 8.29? So you're, I think, discussing the examinations of the devices here. If there'd been anything pertinent to the referral arising in the course of those examinations, then it would have been shared with the relevant officer in Prevent, given how closely the different teams engaged in different aspects of the multi-agency approach in this case worked. I accept this may be an area in which lessons can be learned with regard to proactive information sharing, to ensure roles and responsibilities are clear, and to ensure a clear joined-up approach between different teams carrying out different functions. This is particularly true where an investigation runs alongside a referral. Is this, in fact, a little bit more than just roles and responsibilities? Because shouldn't the Prevent officer have had the professional curiosity to consider what was actually being searched for and inputted into that process?
The Prevent officer wasn't in charge of the criminal investigation, so the digital strategy was down to the officer in charge of the case. And AR wasn't being investigated for any sort of terrorism offences. If he was, he would be sat in the pursue space. PC Thompson isn't an investigator. She is sitting there as a Prevent officer with a very bespoke remit. So I have to be fair to her and ensure that that primacy in terms of that investigative strategy is clear as well.
So I understand you want to be fair to PC Thompson, but I think it's her own evidence that she could have linked in and that she should have linked in at this stage.
I think she should have got the outcome of those digital device examinations and to have understood it. I would like to highlight that we regularly receive referrals through from digital forensic units in forces where they will be investigating a completely unrelated offence, nothing to do with terrorism at all, but they will come across material that of concern that they think needs to be brought to the attention of CT policing. They link in with us on that basis on a fairly regular basis, and we can then look to see whether there is anything of concern in the downloads that they've managed to obtain. So we do work closely with DFUs on that regard, and they are very good at looking at other content that might constitute offences.
Yeah. So there was perhaps oversight to follow up on these points, but in particular, the referral was closed whilst the actions were outstanding. So one might say the evidence pointed to individual error, but also it might be suggested that there was a lack of supervision to catch these points, or a lack of process to ensure appropriate checks were done before closure, or a lack of understanding by prevent officers of the potential importance of this information, or alternatively that it fell between two stools between the FIMU and the prevent. Would you agree with any or all of those?
There was quite a lot in what you've just framed to me there, sir. So
we'll break it down. Supervision.
Yes, the supervision should quality assure that case and make sure that it is suitable for closure, I accept.
What about checks at the point of closure apart from supervision?
How do you mean, sir? Sorry.
So is there a process when a referral is closed to ensure that all information has been gathered?
That would be the supervisor's responsibility.
Yeah. Built within this, is there any concern that there was a lack of understanding by prevent officers of the potential importance of this information?
I don't believe they underestimated the potential importance. I believe that they understood that AR was under investigation for criminal offences, that digital strategy was not theirs, but that if anything came to light that was relevant, they thought that would be referred back into them. But I do accept that they should have checked that prior to closure.
Yeah. And where this was information that was being sought by the FIMU, but was also relevant to prevent officers, was there a risk that it fell between two stools?
No, I don't believe so, because that case had been passed to prevent at that point, so prevent had ownership of progressing that.
Thank you. Move on to the strategy meeting, which was on the 17th of December 2019, and it was attended by social care, mental health practitioners, the investigating officer from Merseyside Police, the community safety team and education. I think, would you agree that was an example of good practice and a wealth of information was gathered by the prevent officer in attending?
Yes, absolutely.
Is it common practice for prevent officers to attend meetings like that where a referral has been made?
Yes, they are regularly invited to strategy meetings where required.
Thank you. And are there systems in place to ensure that that actually happens?
They would be invited directly, but there is good multi-agency engagement, and if there are any concerns in relation to an out of office, for instance, on that email, I'm comfortable that they would have the relevant contact details to be able to make sure that somebody attended.
Thank you. Moving on to the Vulnerability Support Hub referral, could we have up on the screen, please, CTP NW 30122? And if we could have page 24, please. So we'll see in the top left here, dated the 23rd of December 2019, and that this was the PCMP, is that the Police Case Management Plan?
Yes, that's correct.
Thank you. If we could have the bottom third of the page enlarged. We see there under complex needs, there is quite a lengthy explanation of the complex needs that there's a paragraph of explanation of the complex needs that AR had. And then under comments or further inquiries, the schools referred the subject to CAMS, forensic CAMS, and for ASD assessment, a referral to the Vulnerability Hub to be submitted by Prevent. We know that no such referral was made. Could we have now, please, on screen page 50 of your statement, paragraph 8.53? So you address this here. Just before we look at that, the role of the Vulnerability Support Hub was at least twofold, wasn't it? On the one hand, they might be able to direct a subject to appropriate treatment or help a CTCO to direct them to appropriate treatment?
Yes, they could help the CTCO to navigate how that individual is engaged with mental health services.
To find their way through what can be quite a complicated series of teams in the community for mental health. But they're also a consultancy service, aren't they? So they're able to guide the CTCO on how to handle subjects who have mental health issues or neurodiversity.
They can do, yes.
So at your paragraph 8.53, you say, I'm not able to confirm whether this referral took place and the reasons why it might not have occurred. I do note, as the CTCO did, that the support AR needed from other agencies for his vulnerabilities was already in place. But would you accept that that was actually only part of the role that the Vulnerability Support Hub could have played here?
The Vulnerability Support Hub and the CCS, as it is now, operate alongside the police-led partnership space, more so because they are there to guide prevent officers when potentially there isn't that mainstream mental health safeguarding already in place. So they are, but they would have to be formally tasked in relation to post PGA, that case being adopted, and then the clinical consultancy service, or VSH as it was then, conducting any specific relevant inquiries that were required to assist the CTCO.
But PC Thompson wrote that she was intending to make the referral to the Vulnerability Support Hub at this stage that we've just seen, didn't she?
Yes, she did write that, yes.
So the Vulnerability Support Hub could have assisted at this time, not just in identifying agencies for his vulnerabilities, but also in guiding PC Thompson on how to deal with those vulnerabilities and assess them. Is that right?
I think PC Thompson mentioned in her evidence that she felt that there were other mental health arrangements already in place in relation to AR, including CAMS and FCAMS, and that he was waiting for an autism assessment, I believe, back at the first referral stage. So there was a lot already ongoing there, and mainstream safeguarding was what PC Thompson was reliant upon in order for AR to get the relevant help that he needed.
Forgive me, I'm not asking about that. Can I give an example? So PC Thompson said that she attributed some of the things that AR said to his autism. And the implication of that might be that his autism was an explanation for his comments rather than an indication that he presented an increased risk. Do you understand that distinction?
Yes.
There's a problem with analysing AR as someone who either has mental health issues or is a risk. Do you agree?
Yes, the two can intersect.
Thank you. So the position may have been that in AR's case, his autism actually increased his risk.
I think it was touched on before that autism can either be a protective factor or a risk factor, and it's very much on an individual basis.
Yeah. And the Vulnerability Support Hub could have assisted PC Thompson with that question, correct?
They could have potentially.
On the one hand, there's a level of human error in not making the referral which should have been made. But again, is this something that ought really to have been picked up at closure, that important input was missing?
I think there should have been probably clarity given at that point in terms of if PC Thompson felt that the mainstream mental health services that were already engaged around AR were sufficient. That probably should have been clarified so it didn't read like it does now, like it's an outstanding action, yes.
But again, is that not missing the point that the Vulnerability Support Hub could have given guidance to PC Thompson on how to assess AR's autism?
Potentially, but at that point, he still wasn't formally diagnosed. He was awaiting that formal diagnosis, and he had multiple mental health services engaged around him. I think if PC Thompson felt that there were gaps or concerns in that provision, then yes, she could have gone into the Vulnerability Support Hub. But there are a lot of other mental health services engaged with him at that time.
DCS Kenwright, sorry, I'm not asking about provision. I'm asking about the VSH guidance to PC Thompson about how to assess AR and his autism. Do you understand that?
Yes, I understand that, yes.
In terms of picking this up at the point the decision was closed, should this have been picked up by a supervisor?
Ideally, yes.
Yeah. And would you have expected PC Thompson to have had, were there any processes on closure other than the supervisor to ensure that actions of this nature weren't outstanding?
I don't believe so. I don't think PCMT is structured in the same way as NCIA is, where you saw that individual action earlier on. So you get an action, an action result, and an action closure. I think it might be slightly different.
Okay, so if you could have set an action on the PCMT, might that have precluded you from closing the case because it would have been highlighted to you that there was an action outstanding?
I think that sort of structure would be helpful in the system, yes.
Thank you. And then, I don't know, are you able to help from your perspective as to the reasons why this might have been missed? Could it have been a lack of understanding of the importance of the Vulnerability Support Hub, do you think?
No, I don't believe so. I think there was excellent engagement and relationships between the Vulnerability Support Hub and the CTCOs, and they could recognise the benefit that they could bring them in relation to adding value to cases where required. So I don't think it's a lack of understanding per se, no.
Thank you. I want to move on to the visits to AR. So PC Thompson visited AR to carry out a risk assessment and determine what to do thereafter. It appears that AR's case was moved to a police-led partnership to allow that to happen. Did you hear the evidence about that?
I saw that, yes.
Yeah. It's right, isn't it, that AR didn't actually need to be moved to PLP for a visit to take place?
I believe that to be the case. I think the policy states that ideally a visit wouldn't need to be conducted at PGA stage and should only be done in exceptional circumstances with some supervisory oversight in relation to that decision. Carmen discussed this with a supervisor and on a supervisor's recommendation it's been moved to PLP to enable a visit, so I don't know whether that is just a misinterpretation of the policy as it stood at the time.
Thank you. I just want to explore, please, the question of disguised compliance within the outcome of that visit. Could we have up on screen, please, CTP NW 30135? Thank you. And just looking at the top of that page, third paragraph, the subject stated that he felt the school had taken things out of context in relation to his behaviour and online activity. When he was asked about researching the internet for school shootings, he said he had seen a news article on Yahoo and had clicked onto the article as he was interested in it. He told officers that he'd not actively searched for this. The subject then told officers that he had looked on the internet for, I think that should be nunchucks, on the school internet. He said this was research for a lesson where they had been building things. The subject said that he had explained to the teachers the reasons why he had looked at these things on the internet, but that they still wrote it down anyway. He said that he felt that they were always writing things down about him to get him into trouble. Can we just please look now at the referral form, which is CTP NW 30154. Thank you. And if we could go to page 3. And we have some of the complaints that were made at the time the referral was made. Looking at the first substantive paragraph after the date 15th of November 2019, we see the report from the teacher. During the ICT lesson today, I found AR searching school shootings in America. When I told him to stop and get on with his work, he tried to engage in a conversation about the subject, but was told this was not going to happen. I've been told that we can no longer log school web history. And then if we look halfway down the next paragraph, sorry, if we could just keep that enlarged. So there's some information about, under action by Sharon Evidence, form tutor to Axel, some information about discussion with the AR's father. And in the middle of that paragraph, Dad returned a call a few minutes later, informing SE that AR had only copied behaviour of another student and that he clicked on a hyperlink in a news story. And then need a few days to get a copy of AR's browser history we see there. Can we look, please, then zoom out and look at the bottom paragraph, 3rd of December, 2019. Within art lesson working with oil pastels colouring in Call of Duty images, AR commented, why can we have these with guns but can't look at, and then look at the next section, guns on the internet, and then said, can we have a picture of a severed head then? Mr. Baker replied, this wasn't appropriate and changed the subject, etc. And then if we look at the next entry, also on the 3rd of December, in workshop, AR was discussing different YouTubers and YouTube videos. I couldn't concentrate on exactly what he was talking about or who, but I think he was discussing with another pupil videos of people hurting themselves. He also made a comment about if a drill bit broke off and could fly off and kill someone. He was quite graphic. And then, of course, we know in the meeting we saw the discussion of nunchucks. We see here, don't we, a variety of reports that AR was looking at, violent imagery online or was seeking out violent imagery online. Do you agree?
Yes, it appears that way in terms of what the teachers have written, yes.
Yeah. And school shootings was part of that reporting, wasn't it?
I believe it was as has been described, a news article, a single news article of a Daily Mail article of a school shooting that had happened the day before.
Yeah, so I think that's what we know now with
Yes.
this school browsing that's been received, but that wasn't known to PC Thompson at the time, was it?
It wasn't, but it has been described by his father in terms of him clicking on a news link at that point.
Yeah. So PC Thompson said that she thought that AR's account at the meeting, which I think we can have back up again then, it's CTP and W30135, that things had been taken out of context in relation to his behaviour and school activity, and he'd only clicked on a Yahoo article. I mean, would you agree that there was other evidence to suggest that he was doing more than simply clicking on news articles on Yahoo based on the referral form?
He is looking at potentially other violent content, but you have to remember at that point in time that even with the 2019 letter, that VFI, that violent fixation, wasn't part of Prevent Remit. The school massacre ideology absolutely was, and that's recognised by PC Thompson. But the fascination with violence was not part of Prevent Remit at that point in time. I don't say it's not concerning. I absolutely accept that it is. But I have to consider this in terms of Prevent Remit too.
So I'm actually not asking about that, really. I'm more asking
You're
about...
answering a different question.
Okay, sorry.
So the question simply was whether he was doing more than simply clicking on news articles on Yahoo based on the referral form. So, simple, straightforward question.
Yes, so yes, he's doing more.
And can we see then that the account given, there was certainly reason to doubt AR's accounts that things had been taken out of context in relation to his behaviour and online activity?
In what element, sorry?
Well, he's saying that his things have been taken out of context in relation to behavioural activity. When he was asked about researching for internet on the school shootings, he'd seen a news article on Yahoo. But on the other side, the teachers seem to be reporting that on more than one occasion, in fact a number, he has either accessed material of concern, or he said, why can't we have access to images of guns, which might suggest that he was trying to get to them and failing, and asking for pictures of severed heads. That rather calls into question the idea that the school had taken things out of context in relation to his behaviour and online activity, doesn't it?
I don't think that the school have taken things out of context. No, I think that the school are absolutely right to raise the concerns that they did. I think in relation to AR's activity and what is articulated in PC Thompson's action result there, she has tried to address the elements that she felt, I guess, were relevant from a Prevent perspective, but I accept that there's more that's contained in the original referral document.
Thank you. Can we zoom out, please, just to that page as a whole? Thank you. I think that what this is being played against is the evidence that PC Thompson gave in her oral evidence that she considered disguised compliance and discounted it. On the basis of that issue, and we'll come on some more, don't you agree that there was evidence of disguised compliance?
There is a mixture there in terms of what AR has said. So he's mentioned about the news article, but then he hasn't mentioned any of those other elements that the teachers have made reference to. whether that was clear in the conversation he was having with PC Thompson, with parents present, I don't know.
Could we look, please, then at the middle paragraph? When the subject was asked about the recent incident, he'd been arrested for, he said, I think he'd been arrested for, sorry, I don't think it's quite follows, but what he said, he carried out the attack because he was bullied for a number of months. He told the teachers and they had not done anything about it. And then he goes on to say the officer asked the subject why he thought he had been bullied, and he said that he thought the individual that was bullying him was jealous of him because everyone at his previous school liked him. Can we have up, please, the day book, which are the notes that PC Thompson made at CTP Northwest 30175. Sorry, I think that's the wrong reference. Sorry, it's 157, my apologies. Thank you. Page 13. And the middle of the page, there's a paragraph starting, Satan boys picking on him. This was not the case. They were trying to engage, made comments about the staff saying they were evil, bizarre behaviour. So I think this is a report from a teacher at the school about at the strategy meeting about AR's report that he was being bullied. And again, do you see here the information from the teachers calls into question AR's account that he was being bullied?
Yes, well, he's consistent in his account that he perceives that he's being bullied, but I accept that the teachers have investigated that and found no evidence of it.
Yeah. And just finally, back to the note of the prevent visit, CTP NW 30135. Thank you. And the bottom of page 2. Sorry, actually, I think we need to start at page 1. The bottom of page 1, the last sentence that goes over the page. He has no grievances against any specific groups, and then turning over the page, please. The recent assault was aimed towards a pupil that was bullying him. However, an innocent person who had not been involved ended up being assaulted. And then if we could go back again, please, to the day book. Sorry to jump around, but CTP NW 30157. And page 9. If we look at the middle there, it says stated, and again I think account from the teachers, stating he did intend to kill him. Teachers were chasing him, so he assaulted, and then we have the name of the victim, as he didn't want to get into trouble for nothing. Do you see that there?
I do, yes.
And again, we see, don't we, a contradiction of the account given at the meeting and the account that was given by teachers at the strategy meeting. Do you agree? I mean, the initial account was that an innocent person who'd not been involved ended up being assaulted.
Yes.
But the information given here is that he assaulted someone else because he didn't want to get into trouble for nothing. That's a slightly different picture, isn't it?
Yes, it appears like he's lashed out at somebody who was nearby, yes.
And Would you agree that the fact that the person that was attacked was a random pupil was concerning information when assessing AR for the purposes of PREVENT?
It's concerning information overall, I think, for the purposes of assessing him across that multi-agency setting and how his behaviour is subsequently dealt with.
Yeah. You talked about how a visit should be used in exceptional settings. Oh, sorry, only in exceptional circumstances.
Yes.
And I think we can also please pull up your statement at page 40. Looking at the bottom, 8.24, and just looking at the bottom final sentence, the possibility of ASD, the history of bullying and those evident traits were also taken into account in the CTCO's interactions with AR. And if you turn over the page, please. And was factored in considering whether he appeared to hold an obsession with school shootings. The conclusion was reached that while he may have had an interest in such things, his behaviour at the home visit did not indicate fixation. This reinforces the utility of in-person visits with the subject. Do you see that there?
Yes, I do, yes.
We don't need to bring up the picture, but AR was very young looking at the time this visit took place, wasn't he?
He was, yes.
Yeah. And is it right that referrals for young children are sadly common within the context of PREVENT?
Yes.
Yeah. Are CTCOs trained on how to deal with referrals from young children?
Yes, it is commonplace, as you say, in their casework, and they will be taught about that within their CTCO training.
Yeah. In this case, I think PC Thompson said that she considered the concerning comments that AR made, but put them down to his autism,
Yes.
and therefore discounted disguised compliance. 2 points out of that. Is that again something where the VSH could have assisted in terms of analysing the impact of autism on the things that were being said at that meeting?
Potentially, yes.
And secondly, looking at the examples of the difference in the accounts that were given, would you agree that the possibility of disguised compliance should have been given more consideration?
That's a difficult one for me to answer because it's Carmen and her colleague who were in that situation. She was with an experienced colleague as well. So I have to rely upon their professional judgment, the fact that they acknowledged that they understood that disguised compliance could be the case. They know that children might lie and that parents might want to create a perception of their children that is good, that they're aware of those things, and they had to consider that in the balance along with the other information that they had available to them at the time.
Let me put the question in a slightly different way. I think PC Thompson accepted in hindsight that that was something that ought to have been given more weight. How does CTP Northwest ensure that CTCOs are able to take into account these issues and do give appropriate weight to them?
They are taught to consider disguised compliance as part of their training, and it's very much every case on its merits. They rely upon their own experiences of case management. They rely upon their peers and they rely upon their supervisors, as I think was described really by Carmen and her colleagues, in terms of that real team approach to try and get the right outcome.
Thank you. So I'm conscious of the time. We started slightly late, so I might ask for your patience to continue.
Most certainly, Mr. Ward. Yes.
I will ask that if the stenographer has any issues that a message is passed my way.
Thank you.
DCS Kenwright, moving on please then to the decision to close the first referral. I think we've touched on this and the issues of ideology. And we've also looked at some of the language that was used by the FIMU to prevent officers. Were you able to listen to the evidence of PC Thompson and some of the language that was used by prevent officers in referring to AR's case? So,
Yeah.
so can I just give some examples? That that home visit says subject did not display any extreme views of CTDE ideology. During the conversation, he has no interest in politics or religion. The record setting up that meeting, and sorry to take this slightly out of order, but on the 23rd of December 2019 said that AR needed to be spoken in order to clarify his ideology. A record on the 8th of January 2020 said the FIMU assessed that the case can now be closed to prevent, as there are no new CTDE concerns present at this stage. So just for your reference, the first is from the visit action, which was 135, and the others are on the PCMT, which is CTP Northwest 30122. I think you accept in your statement that the terminology used in this context was ambiguous. Do you agree?
In relation to the close to
So
prevent
if we-
comment?
Yeah, so yes, exactly. So we've talked about the FIMU side of contact. I'm now asking you about the wording used by prevent officers. So perhaps if we have up your statement at page 37. And paragraph 8.10. You are perhaps slightly more narrowly in the context of the NCIA action there, but saying that the terminology closed to prevent is ambiguous. Is that more specifically at the NCIA action that you're referring to here?
It could be ambiguous in either setting, I think, taken out of context and without the rationale of the officers that have written it.
Yeah, so it's perhaps another side of the same coin we've been talking about, but saying, for example, no CTDE concerns or no ideology might be confusing at the prevent, if used by a prevent practitioner.
Not necessarily, because they would be considering school shootings, mass casualty events as part of that ideology assessment, and mixed, unclear, unstable ideologies as well. So whilst it's not a clear single ideology per se, they are describing them as a collective of ideologies, if that makes sense.
So your view is this is a language issue, but to the prevent officers, they would have understood what was being meant. They were referring to prevent relevant. Is that right?
Yes, absolutely, yes.
Thank you. And to the extent that that wider prevent relevant question, thanks to, as you've said, the joint letter, that included the issues of school massacres and mass violence. Is that right?
Yes.
Thank you. Just putting to one side the process issues about the school browsing history, the vulnerability support hub, and the disguised compliance. Can I just ask you about things that were known to PC Thompson at the time she dealt with the referral in relation to school massacre ideology?
Yes.
So, first of all, on the PCMT, school massacre ideology had been entered, but I think PC Thompson didn't think that it was by her. Is that right?
I don't know if it was entered by her or somebody else, but it's certainly featured on
that.
that.
The evidence. Yeah. So that CTP NW 30122, page 7. AR had also been researching school shootings in America during class, or at least we knew that he'd clicked on one article, correct?
He'd looked at one article, I believe, yes.
He'd made comments about teachers getting murdered, we see on the referral form, correct?
Yes.
Did you hear the evidence that PC Paul Harrison had emailed PC Thompson saying that AR had a certain hatred of teachers in particular?
Yes.
So that's LANC 30175, page 77. PC Thompson knew that AR had been temporarily excluded for assaulting a fellow pupil in class. Is that right?
Which referral are we
First
considering
referral.
now?
Are you aware of whether she would have known that or not?
Been excluded for assaulting a pupil in class.
Yeah.
I don't know if she was aware of that
We'll
one.
move on perhaps to the more obvious ones. He'd taken knives into school,
Yes.
that he said that he hated his school, that he was bullied and felt teachers were picking on him,
Yes.
that he'd returned to his school despite the exclusion with a knife and adapted hockey stick and struck a pupil, not the alleged bully with that hockey stick,
Yes.
that he said he would have used the knife, correct?
Yes.
If school massacres are an ideology, then to prevent eyes, couldn't that have been classed as an unsophisticated form of attack?
I don't believe so, no.
DC Blundell, I think, said that AR had acted out his fascination. Did you hear that evidence?
I'm not sure that I did, no.
Okay. That was all wrapped up in an apparent interest in violence. I think you said that wasn't part of the joint letter, but would you agree that it was concerning things like asking for pictures of a severed head in class?
Yes, it is concerning.
PC Thompson said that she had considered these issues and considered the issue of school massacre ideology and didn't consider that a referral should be made. With your knowledge, wouldn't you agree that it might be said that there was enough here to establish simply reasonable grounds to suspect that AR was susceptible to becoming a terrorist or supporting terrorism?
I don't believe that he's met that threshold. I can understand why Carmen made that decision.
You make the point that it's a subjective decision.
Absolutely.
But it's right, isn't it, that all of the three post-attack reviews, so the Lord Anderson review, the Prevent Learning review, and the Dignate report, took the view that AR's Prevent referrals may have been prematurely closed as a result of overemphasis on the absence of a particular ideology.
They do say that, but Carmen has stated that she's taken into consideration that school massacre ideology and didn't believe it was made out.
And you heard the evidence of Miss Elsmore that she would have expected the case to be taken to Channel as well.
I did hear that, yes.
After that referral was closed, are you aware that information wasn't passed on to the Lancashire Police Community Safety Team to say that it had been closed?
Yes, I am aware of that.
And the sergeant from that team considered that Prevent was still holding AR's risk, if I can put it that way, and that Prevent was the lead agency when looking at AR's case. Do you think that was a fair characterization of the position at that stage? Is Prevent the lead agency at the time a referral has been made?
I don't believe we are at that point in time.
And how do you see the different agencies fitting together?
So, firstly, there's a criminal investigation ongoing in relation to AR's activity at the school. But there is a collective responsibility, a shared responsibility in terms of how AR is managed through those multi-agency arrangements.
Would you agree that that police community safety team should have been told that the referral had been closed?
I think if we felt that there was something that the community safety team could have assisted with in terms of AR, it would be useful to use that onward referral mechanism, if you like, to notify them as well.
When you say onward referral mechanism, that would simply just be a matter of making contact and telling them, wouldn't it?
Yes.
And in what circumstances should a marker be put to say that someone has been referred to prevent on police systems?
That has to be when the case is formally adopted.
So you wouldn't expect a marker to be put down where someone has been referred but not adopted, is that right?
That's correct.
Thank you. Moving on to the second referral, I think you were able to see the evidence of DS Trahan.
Yes.
Is that right? Are you aware that the PGA refers to the issue of internet usage, which was consistent with the referral, i.e. there were pictures of Gaddafi? Did you see that?
I'm not sure I did now.
Okay. Perhaps you'll take it from me that the internet access section of the PGA was filled in,
Yes.
but the other sections such as ideology and grievance said non-evident at this stage.
Mm-hmm.
Is that familiar to you?
I think so, yes.
If you want me to pull up the document, we can.
Okay.
Is that an okay yes?
I'll
please?
see how the questioning
Fine,
goes. Thank you.
So just for your note, the reference is CTP NW 30124 and it's pages 14. And onwards to 18. DS Trahan's supervisor comment referred to being unable to see the previous referral. Would you agree that when a repeat referral is received, the exercise remains the same? It was to carry out the PGA and just to assess whether someone was vulnerable to being drawn into terrorism?
Yes, if they felt that it had met that suspicion threshold at that point.
So they were carrying out the same test, effectively on a repeat referral, correct?
I believe so, yeah.
Yeah. Would you agree that to do that, one has to see the first referral?
Yes.
Yeah. So, I mean, I think DS Trahan accepted that she should have had view of that, but her approach might show that this referral was taken and analysed against a closed referral rather than being analysed, rather than AR being analysed afresh. Can you follow that?
I understand what you mean, but there was certainly a cross-reference on the PGA to the first referral, that the CTCO had ensured that there was consideration given to that first referral still.
So PC Thompson had given a summary of the first referral, but would you agree that it was quite a brief one, and it didn't, for example, refer to an assault actually having taken place at the range?
Yes, it was a summary in effect.
And do you agree that repeat referrals should be analysed holistically? So in other words, there should have been a re-analysis of AR as a whole rather than simply analysis of the post that had been made?
Yes, I think information has to be taken in the round, including that previous prevent referral.
And it's true, isn't it, that the same approach, at least in terms of the full setting out of information in the Prevent Gateway assessment was taken to the third referral. Do you agree?
Yeah.
And so I think, do we see again that the repeat referral was treated as an addition rather than a full analysis of AR as a whole?
I believe that PC Thompson has considered the 3 referrals together and has made reference to them, if you like.
There was, I think, at this stage, no policy on how to deal with repeat referrals, so in 2021. Is
Yes,
that right?
I think it came in 2023.
Thank you. Were you aware of that causing difficulty or any challenges for CTCOs?
Not that I'm aware of. I think they would utilise what information they had available to them.
Thank you. Could we have up, please, your statement at page 33? And I'm looking at paragraph 7.17, just asking for your overall reflections. So you said overall the PLR concluded that there had been a high level of compliance by prevent officers in terms of process, timescales, completion of assessments, and general, if we go over the page, adherence to policies in place at the time. I recognise that the authors didn't agree with the decision to close the referrals. For context, I should reiterate that there is no specific or fixed threshold for referral to channel. Officers conducting the necessary assessments will take an overall view on the risks attached to the individual case and the person's susceptibility to being drawn into terrorism or being radicalised. As such, there's an element of subjectivity to the decisions taken, which are made on a case-by-case basis, based on the intelligence available in a number of potentially reasonable decisions in any given case. I think we've covered that already, haven't we? The subjective element to the decision.
Yes.
And I think it's your view, is this right, that subjectively PC Thompson took into account the relevant considerations?
Yes, I believe she did.
As reflected in the PLR, the teams dealing with these referrals operated in accordance with the policies in place. That was your view at the time you wrote this statement. Having heard the oral evidence, do you agree that does that remain still accurate?
I stand by that. I do accept that things could have been done better in terms of some of the use of language that we've touched upon and some of the closure of outstanding inquiries, that they should have been followed up.
So if we were to change that wording from policy, accordance with the policies in place, to in accordance with the expectations on the CTCO, for example, would your answer be the same?
I think the CTCOs, certainly Carmen has stated that it would have been better that she followed up those inquiries prior to closure. So, and I think there would be an expectation both from me and from the supervisors that took place.
Thank you. If AR had been referred, that would have been a question of consent. There would have been a question about whether his parents consented, correct?
Correct, yes.
And I think we've heard from Ms. Ellsmore about what could have happened if AR had consented to interventions such as mentoring or an intervention provider. Is that right?
Yes.
Did you hear that evidence?
I did, yes. I just don't know if there was the breadth of intervention providers that we have available to us now. So they were very ideology-based, traditional ideology-based at the relevant time.
But this is right, isn't it? That would there have been the availability of mentoring at that time?
I would have to double check, but I think that the mentoring was more around that intervention provision and that being about very much around sort of religious ideologies and giving an alternative, more moderate view to individuals who were potentially interpreting religion in a certain way. I think we have got a much better breadth of intervention providers now that would assist CTCOs with both the sort of school massacre ideologies and the violent fixation elements that we see in the casework.
And obviously, if consent hadn't been given, AR, if we run the hypothetical forward, would have been run under a police-led partnership.
He could have been, yes.
And I think we heard from Ms. Elsmore that would have included an element of risk management.
Yes.
Yeah. And presumably it would have raised concern if AR had refused to consent or refused, his parents had refused consent or he'd refused to engage with measures that might have been put in place. Do you agree?
Yes, you would hope that individuals and families would take those opportunities.
So I know the time. I'm moving on to changes and improvements, which I will seek to go through very quickly.
Certainly,
I think in the next 10 minutes, obviously it's important evidence. I think we've touched on this, DCS, Ken, right? But in terms of the FIMU work and that language, is this right that there is now a new referral form and also revised NSIM guidance on the language that should be used and how they should be working with prevent officers?
Yes.
Thank you. Are you satisfied that the issues about lack of clarity of language, and if there is any issue about understanding, that those are now improved?
I think that the ongoing NSIM review will help to strengthen that, and that will subsequently be reflected in training as well.
In terms of resourcing of Prevent, I think the evidence we heard was that the Prevent was well resourced at the relevant time. Has the resourcing of Prevent changed since 2019, 2022?
I don't think it has substantially changed in terms of the numbers of people that we have working within Prevent. And they are exceptionally busy right now. As we heard Catherine Elsmore state that the number of referrals have increased significantly, and it's placed a significant pressure upon Prevent teams.
So there are similar numbers of CTCOs, are there?
Yes.
Okay. But they're dealing now with an increased caseload, is that right?
Yes.
Yeah. Thank you. In terms of picking up outstanding information, again, we've touched on this, but I think you suggested that it would help if the PCMT had a way to pick up outstanding actions. Is that right?
Yes, I think we always need to try and make best use of technology, and whether that is mandatory boxes that need filling in or actions that need to be resulted. That all helps give some structure, I think, to how an individual can manage their casework.
So there is, I think, a new system called the PCMT. Are you familiar with how that works?
I'm not a practitioner, so not to that level, but I know it has made some improvements, I believe, in terms of the case management system.
Thank you. The policies about multiple referrals and ideology, I think we've picked up with other witnesses. I think, is this right that there was a CTP Northwest review or look back at cases which were said to have had school massacre ideology or fascination with extreme violence?
Yes.
And I think that review found that there had been 33 cases over the year, 15 not compliant. I think the majority of those were due to lack of III checks. Could you just explain what that is and what the issue was?
Yes, III is Internet Intelligence Investigations. So this is about online checks, if you like. So there has been work done between the intelligence unit and Prevent to ensure that There's real clarity now in that handover process so that prevent officers understand what an intelligence assessor has done around triple-I checks, because if there are identifiers, social media handles, etc., that are included in an initial referral, then the FIMU assessor will check those themselves. It would only be if there were certain checks that weren't done, or if a CTCO became aware of other identifiers, that they would subsequently get those other internet checks completed.
And I think there were 2 referrals that were reopened. Is that right?
Yes, I believe so.
Yeah. Did that review cause you any concerns about how historic cases of school massacre were being handled in general by CTP Northwest?
I think that triple-I aspect is really important for us to get right, and I know there is some national work ongoing looking at that as well, because there is a necessity just to make sure that we aren't duplicating, both in terms of effort but also around our legality and proportionality of what we do. So I think that will be a really useful piece of work to help shape how we move forward, but I think we're in a much better position now.
And is that something you would look for a policy from CTPHQ to address?
Yes, I believe that is what they are doing. So there are mention within the current policies around triple-I checks, but there is further work ongoing in relation to the relationship between intelligence checks and then what the prevent officers are expected to do as well.
You also state at your paragraph 8.1 about the CTP Northwest Change Team being commissioned to review prevent processes, and I think that was due to report this month.
Yes.
Has the report been received yet?
No, not just yet, but I can certainly provide any recommendations that come out to the inquiry.
Please do, thank you. Just final questions, please. Could we have up, please, page 41, paragraph 8.26? So you grapple here with the kind of wider philosophical question of what the appropriate delineation of responsibilities is between prevent and other bodies to deal with violence-fixated individuals and similar issues. Is that right?
Yes.
From your perspective, is the current position in relation to ideology and violent-fixated individuals appropriate and sustainable?
I would say that some individuals within the VFI cohort are susceptible to being drawn into terrorism, but there are others within that you could classify as VFI that aren't. I think the thing that we've got to try and tackle across agencies is how we approach the underlying issues that are causing multiple vulnerabilities. So a susceptibility to being drawn into terrorism is just one of 14 vulnerabilities that policing looks at. It's complex, but those vulnerabilities are effectively starting to become behaviours that are caused as a result of underlying issues, whether that's adverse childhood experiences, whether that is an autism spectrum condition or neurodiversity that is making them more susceptible to what other people tell them. So it is a really difficult and complex field.
And do I take from that you think that, might you be suggesting that some of this work might be for other elements of policing than CTP Northwest? For
for other
CTP in
elements of
general.
policing and for other agencies as well, because we certainly don't have all of the tools in the box or the professional knowledge from a policing perspective to tackle them all on our own.
And do you think that there are appropriate pre-crime mechanisms for violence-fixated individuals, for example?
I feel like there may be a gap there. I think that there are statutory multi-agency arrangements that exist. So you've got MAPA, for instance, but it very much talks about offenders. You've got MASH arrangements, but they are very much focusing on the information sharing and coordination of agency activity around safeguarding. And I think there's got to be something in the middle that isn't just around terrorism, but is around that wider harm that a person may present.
And perhaps just slightly following on from this to a counterfactual, if AR's home had been searched in March of 2022 after he was found with a knife on the bus and ricin seeds had been found, would there have been any role for CTP Northwest in that scenario?
Potentially, yes, I would be having that assessed to see whether there was actually a Pursue investigation that was required, so it would be assessed from a Pursue perspective.
So you would be looking for ideology in the FIMU, the SU sense?
Yes,
right?
and through my investigation team as well, I would probably have a CTSIO, a senior investigating officer, look at the circumstances to see whether it met any specific tact offences.
So, for example, the Al-Qaeda training manual had been found on the devices?
Yes.
Those are my questions. I'll just give the opportunity. Is there anything else that you would like to say?
Just to reiterate what I said in my my corporate witness statement in terms of passing on the condolences to the families, that I think you've probably seen that the officers from City Police in North West come into work every day to try their best to help to protect people from terrorism. And we will do whatever we can to engage with the inquiry in terms of phase 2 and contributing to any recommendations.
Thank you. I'll just look to see if there are any other questions. I'm seeing shake heads.
It's been a long afternoon. Thank you very much indeed, Detective Chief Superintendent. You're now free to go.
Thank you, sir.
So we have DAC Evans and Mr. Hunt. DAC Evans from CTPHQ and Mr. Hunt from Home Office to give evidence tomorrow.
Tomorrow. And sitting at 10 o'clock?
Yes.
Yes. I'll sit then.